All right, everyone. Welcome back to the Conversations, part of our podcast here. This week, we are very excited to have Mathieu Picard with us. He is a lawyer that I know. He also lives local to me in the New Brunswick area, in Moncton, New Brunswick area. And Mathieu is unique in that he is a lawyer now and represents clients in many different types of cases, but there was a period of time where he was one of the judges with the Social Security Tribunal. In fact, he was one of the first group of people that were judges with the Social Security Tribunal. So, Mathieu, we just wanted to welcome you here today. Sorry, frog in my throat. Wanted to welcome you here today. It's going to be interesting to hear from you. I know our audience is going to love this, but why don't you just start by telling us just a little bit about you? And I've given a little bit of an introduction, but just tell everyone who you are, what you're all about.
Well, Dave, I was raised and born in New Brunswick, practicing for many years now in the field of personal injury. Not like you, I don't do much of CPP disability claims anymore. I do some, but not as much as what you do. And I also do some LTD cases, but mostly injury cases arising from motor vehicle accidents, slip and falls. That's pretty much what we do here. That's what I do as a lawyer. I've been in this field for over 10 years now. I really enjoy it. It's good. I mean, you have a real sense of trying to help people that experience something traumatic in their life. So that in that way, it's a very fulfilling job, and I really appreciated that. And for a while there, I was a member of the Social Security Tribunal. It was also a very interesting experience. It's a different experience.
Yes.
Because I'm not tasked with representing someone. I was tasked with finding a fair solution to appeals that were presented to the Social Security Tribunal, and I was only doing mostly CPP cases, and some old age as well, but mostly CPP cases. People applying for CPP disability, and they were rejected once, rejected twice by the department, and then they would decide to proceed with an appeal at the tribunal. So that's what I've been doing for a couple of years. It's a different perspective as a lawyer now. I know and I feel what the trier of fact is trying to get from the evidence. So that's a different perspective in that regard. I'm not sure if I'm a better lawyer because of it, but I'm a different lawyer.
You're definitely not worse.
I'm not worse. No, I'm just a different. I have a different perspective.
Yeah.
So sometimes I'm going to look at cases thinking, what should I present to the judge to have a convincing case? And that part of the thinking, although it's always there, is I would say a little bit more present.
Yeah. And just so people are clear, Mathieu, like you were the guy when people, they do they apply for CPP disability, they do their appeal, and then it gets denied, and then they have to go to the Social Security Tribunal. You would have been the guy when they get to their hearing. You were the guy that was the quote-unquote judge or the member who hears the person and makes the final decision, basically.
Yeah, I was tasked with listening to the evidence, to the witnesses, looking at the submissions, and rendering a decision based on the law and based on my appreciation of the facts.
Yeah. Now, I'm kind of a fanboy. I've made no bones about it. I'm quite a fan of the Social Security Tribunal, especially the management that's there now. They've been very forward-thinking. I'm not sure if you're aware now, but almost all the hearings are done now by Zoom. It's very user-friendly. Mathieu, take us through, so people understand. So you were appointed as a judge. You came from a lawyer as a background. Was there any type of training? What goes on when you get there? Do they teach you, how do they teach you how to handle doing these cases?
Well, I was appointed amongst the first, I'm going to say the first 50 members, maybe, to be appointed. So they were still working in firming up and putting in place a process. But there was in place already a great process to train people. Yeah. We all show up with our experience and background. That's the same thing for a judge, same thing for a tribunal member. But we also benefit from experience and training from the staff. They are very capable staff there who would spend time explaining the law to us, teaching us how to proceed with hearings. It was a very, very good experience for me in that regard.
I have no doubt. It's well run. In fact, I've gone so far as to say, it is a model in Canada for how to run a tribunal or a court.
The technology that they've been using is just amazing. were ready for COVID before COVID was there. Okay,
Yeah.
like they were paperless tribunal. They were allowing members to work from their home through secure connections. I mean, they've been doing everything right. It was a slow process because it's government and it's a big organization.
Yeah.
But in terms of deploying technology and deploying the tools needed for members to do their job, it was great. It was fantastic in that regard. I mean, there were some challenges initially when we started with hearings back in 2013, 14, 15. There was a significant backlog of cases that were related to the transition
Yeah.
from the previous system, the new tribunal. But once we were able to get through this backlog, I think now they have in place a really good system. And I've not been there for a couple of years now, but when I left, it was already an amazing system in that regard.
Oh yeah, no, they're very good. They're very data centric. In fact, I got an email this week where they were publishing. They send out statistics showing how many cases are currently there under appeal, how many. So they're very accountable and they're very good with their data. Now, Mathieu.
There was already a lot of automation also, Dave. So there was a system in the back that would produce professional templates, letters, documents.
Mhm.
So once you're tasked with rendering a decision, you already have not the content, but at least the
Right.
layout
Yeah.
is put in place and it was easy to use. So no, it's amazing what was done in that regard.
Now, tell me, one of the things people want to know, Mathieu, like not everyone, and in fact, the statistics, I was quite surprised when I saw the statistics of how many people are self-represented at the tribunal versus have representation. The vast majority of people are still self-represented at the tribunal. What would you say to someone as a judge? Like, what were you looking for from somebody in terms of the medical information? What were you looking for when you had someone coming before you in one of these hearings? Like, what are the kind of things people should be bringing to the hearing, or or making sure they file it ahead of time, that kind of thing? What kind of things were you looking for as a judge?
Well, the approach would be different if you have a self-represented party versus a party represented by competent and professional counsel.
Yeah.
So you would expect to have very complete, very detailed submissions and documents supporting the appeal if the applicant was represented by counsel. Sometimes it's not the case. So as a tribunal member, I think you have to show flexibility.
Mm-hmm.
Number one, you have to show understanding, and you have to assist as much as possible the parties who are not represented to make sure that the fact that they can't sometimes cannot afford counsel, cannot access counsel,
Yeah.
not allow them to secure a just and fair decision from the tribunal. So my goal is to make sure that look, if there's evidence missing and the evidence exists, we've seen cases that adjournment were granted to help parties secure additional.
Really?
Yeah, but you should not count on that because that's something that is very. It's up to the judge to decide what they want to do in that regard,
Yeah.
and I would not bank on that type of flexibility.
No.
I think number one, what we're looking for is someone who's well prepared, someone who's going to be honest, okay, someone who's going to offer the evidence, and as someone presiding hearing of self-represented litigants or appellants, we need to sometimes guide them by asking the right questions because the evidence might be there. It doesn't mean it's in front of the judge. So sometimes you need to, as a trier of facts, you need to question the parties to make sure that you fully understand their evidence and their testimonial.
Yeah. Absolutely. No, absolutely. It is a challenge, I would imagine, if someone is there and they don't even know where to start. And I do find, at least even when I'm in the hearings, I give the adjudicators, the judges, a lot of leeway to just say, tell me when you want to interrupt. Like, really, like, so how would you prepare? I guess just to jump around a little bit, if you were preparing for, say, you had a hearing coming up, again, you can't speak for all the members of the tribunal, but what was a process that you used to get ready to go to the hearing where the person would come before you and you'd have to make the decision? What did you do in advance, if anything?
I think it's the same as a competent counsel.
Okay.
I mean, you read the file, you identify gaps that you will have to address through questioning of the parties in attendance or witnesses, and you prepare a draft of questions or issues that you would like to discuss. I mean, sometimes there are 2 issues, sometimes there are 5 issues that you need to address with witnesses, and most of the time there's only one witness, and it's the person proceeding with the appeal.
Right.
And so step number 1 is really to have a good full review of the file, to fully understand the evidence in front of the tribunal. You also need to understand, I mean, the law, once you've been in that capacity for a couple of years, the law, you understand it. So really, it's the questions will arise from the fact that will be presented, not necessarily the law. So you need a good understanding of the file material in front of you before you proceed with the hearing. You also have to be ready to present questions to the witnesses.
Okay.
Because the witnesses, if nobody is there for representing the parties, it's almost like an inquiry. You need to ask proper questions and try to understand the nature of the appeal that is presented to you.
Now, what would be, and this is kind of a general question, but generally speaking, like, what would be the biggest mistakes that you might see a self-represented person make when they come to the hearing? With the view to, like, we're trying to educate people how to do a better job with representing themselves. Not, like you said, most people going there do not have counsel or have a representative for various reasons. So if someone is going to go there themselves, like, what is one of the biggest mistakes that you used to see, and what could people do to avoid that?
I don't think it's any different than what we see in a regular court. It's the lack of the proper evidence.
Right.
Evidence might be in existence, but it might not be in front of the court or the Social Security Tribunal. So I would urge people, counsel, appearing before tribunal to make sure that all the evidence is there and has been filed on time, and to afford a fair chance to the tribunal member to do a good review and to understand what's the evidence. When that doesn't take place, it's very difficult, because witnesses will refer to documents that you don't have, will present facts that you're not able to corroborate with the documentary evidence, and that's a big problem.
Oh yeah, I gotta imagine that. There's no probably worse feeling if you, in your gut, think this person probably deserves the disability, but the evidence I need to make that finding, they haven't brought it, or they haven't, and it really puts you in a tough spot as a judge, I would expect.
And an inquiry of facts cannot draw conclusion based on nothing.
Right.
You need a foundation for your decision.
Yeah.
You need a factual foundation to support your decision, and you need the law to support it as well. It can make it legal. And the problem that we see and that you see as counsel is not having. I mean, the role of counsel is to overcome and close the gap on the evidence that is missing. But sometimes it's not possible. And that's a big problem in the context of the CPP disability applications. Some people go without family doctors for years. It looks like they've been disabled. It looks like they should be entitled to CPP disability. But at the same time, the evidentiary foundation is not there, simply because there were no doctors. There was nobody involved for 3, 4, 5, 6 years. And that makes things very complicated and very difficult to win as well from the applicant's perspective.
Yeah, I tell people, like, one of the biggest things we tell people is, whatever you do not go to war with your own doctor. Sometimes, like, people have a legitimate dispute with their doctor over the diagnosis, or they disagree with the recommendations. But I've told people, like, you need to stay in step with your own doctor, right? Because I would expect, like, I notice a lot of the a lot of the tribunal judges, tribunal adjudicators that I appear before, a lot of the questions they bring up are whether people followed up with treatment, what's happened with the doctor mentioned you getting this thing, was it done? So correct me if I'm wrong, but is that a big issue when you're looking at whether you're going to approve a case or deny a case, whether the person did all the recommended treatment, even if they may have disagreed with it?
Well, you have like any relations that you have with professionals, whether it is doctors, therapists, I think as a human being, you want to approach a relationship in a very careful manner because these people are trying to help you.
Mm-hmm.
But they can't help you if you're not willing to work with them. And they have a job to do. I mean, it's okay to disagree, but you have to do it in a very polite, very professional way. Uh, it's okay to seek second opinion. It's okay to seek advice from someone else. But at the end of the day, you should not put at risk a relationship, usually a good relationship that you have with your family doctor, over a simple disagreement. Sometimes I would really urge people to preserve and maintain a good working relationship with their family doctors, nurse practitioners, because at the end of the day, I'm not saying it will hurt the case. I'm just saying it might also hurt your well-being in the sense that if you're not work with people who are willing to help you, it becomes a bigger problem. And we also see it in injury cases.
Mm-hmm.
We have a duty to mitigate our losses. If you sustain an injury, if you sustain an accident, and then a disability arises from these injuries, uh, you have a duty to get better. And get better means working with people that will look after your care. And if you don't do it properly, and if you're not willing to work with these people, well, the outcome might not be so good for you.
Yeah. And it's funny you say that, the mitigation. When you were hearing these cases, what did you look for in terms of mitigation of people like trying to stay in the workforce? Because with CPP disability, as we know, it's not just you can't do your old job. You have to show that you can't do any job. And I know that as an adjudicator, like when I go into these things, I know some of the judges they're concerned if they see a situation where a person left their own job but didn't try anything else. So when you approach these cases, like what were you expecting to see from the evidence or from the presentation around this idea of did they try hard enough to stay at work? What kind of things were you looking for?
I think that the facts with respect to employability should be fully disclosed and presented to the tribunal. So if someone has some sort of residual capacity to work, well, it should have been explored, should have been properly documented, and then presented to the tribunal member in order to fully understand that residual capacity. Sometimes a doctor will conclude that there's some sort of capacity to work and do something, but that doesn't equal necessarily a real ability to. And if you're able to work an hour per day as a secretary, and all your life you work as a carpenter and you have a grade 8 education, well, it's not because your doctor is saying that you can actually work an hour per day. That doesn't mean that you're not entitled to CPP disability.
Right.
That's where having a good, honest discussion with a capable counsel, someone like who's doing a lot of these cases, someone like you, and have a real good discussion about the facts and understanding the law and then understanding the facts. I think that's needed in order to understand your chances of winning an appeal at the tribunal level, at least.
Yeah. One of the things I tell people that I caution them when representing themselves, there's this old saying that a lawyer who represents himself has a fool for a client. It goes back to this idea that one of the big things, like the way I find that we are able to win these cases when, say, a client can't do it themselves, is it's very hard to see what the red flags of your case are. Like, what are the big red flags that an adjudicator or a judge is going to look at your case and say, okay, that's a big problem. What I find is people have a hard job being self-aware enough or critical enough to identify what these red flags are and then address them so that the judge can say, okay, you've addressed that. I understand why that was. What I find is people will either ignore them, they won't see the red flags, or they'll make worse. They'll make excuses for the red flags. Like a red flag might be psychology was recommended, but you never did it. I would say like people will make excuses about that. Whereas if I'm representing someone, I get them to get referrals, to get into it, to admit that maybe they should have did it. And so I find like the problem when you represent yourself is you just may not be able to identify these red flags with your case that hurt your credibility, that make you maybe a little less believable. And that is a big issue. And I don't know what your thoughts are on that.
Right. And as a tribunal member, I think we have, and as a former tribunal member, I think I had the responsibility to explore the red flags and understand them. It's not because the doctor is saying you can work in a sedentary capacity. It doesn't mean that you're necessarily not entitled to CPP disability. So I think there's a duty, and duty for us as well as counsel, to fully explore those, and not on the day of the hearing, but in preparation for the hearing. We have a duty to fully explore what was said by the doctor. Why does it? What would be the reason that it doesn't translate into employment for this person? And then try to understand from that person where there is actually incapacity to work in some sort. And if it's not the case, and then you have to be willing and ready to explain it for your client, and then you should produce your client as a witness and get your client to explain it properly. I mean, red flags, there's two approaches to them. You could try to avoid those way because they will blow up in your face.
Yeah.
We know that as counsel, or you could, or you should try to address those.
Yeah.
So addressing the red flags, and the red flags that we see are the same that we see as counsel. So gap in medical evidence, mitigation that is not properly done. So treatments were recommended, but they were not followed. So now we need to understand: is it because person doesn't have money to access those treatments? Is it because the treatments are simply not available? I mean, there are explanations. If the only explanation is, "Oh, I don't feel like it," well, that's not really good. Okay, still valid explanation. Then, like, the counsel should explore it and should be willing to explain it to the court or the tribunal. It's the same. I mean, the red flags: it's gap in medical evidence, not mitigating, and also the other one that we see often is the residual earning capacity. So the person has a capacity to work. Is it working enough that you don't meet the CPP disability threshold? That's another question, but that has to be explored as well. And it should not be explored on the day of the hearing. It should be explored days, months before, because you might need additional evidence. You might need to get a doctor to explain some of it. I mean, if the doctor is saying psychotherapy is needed and the person is not doing it, well, maybe the person is doing something else that is also very good for the mental health, well-being, and the doctor is okay with it. Yeah, if you don't go to the psychotherapy, but you do meditation, it might be okay from your doctor's perspective.
But you need that documented from the doctor. Yeah.
Or the doctors as a witness. That could also be a very powerful witness. I mean, the family physicians or the nurse practitioners, they've been around the patient for years. They're the best source of information for what happened, the source of disability, the injuries, the treatments. I mean, they've been looking at it, they've been helping with it for many years, and they could be a very good person to produce if they are available.
Okay. We're getting near the end here, but just since you brought up that witness thing, what witnesses did you like to see? Because I have a lot of people ask me, well, should I get my husband to testify? Should I bring in this other person? My view on witnesses, and then I'll let you give your take on it, but my view is you don't just pile on witnesses unless they have a very specific role. Like, I once had a husband testify and it blew up. Like, he completely went off the rails, and I think that it tanked the whole chances of the client. So my view is only put witnesses in there if they have a very specific purpose, and it can't just be to say that they believe you and that you're a good person.
Yeah, character witness. I don't think they will bring much here. I think number one is you need. It doesn't matter what type of witness you want to produce. They have to be reliable, honest, and professional. I mean, if they're doctors, you want someone who's going to be reliable as a witness. You don't want someone who's going to be not honest, making up stuff. You, as counsel, we don't want to see that. Like, you want, at the end of the day, you want the truth, and you want the truth to be explained. You want the truth to be shared with the tribunal member. You don't want someone to make up stuff. You don't want someone who's not reliable. I mean, at the end of the day, lawyers are also officers of the court, and they can partake with someone who's going to be making up stuff and not reliable. So when you're talking about like other witnesses that you were thinking about bringing and they could be damaging, sometimes they're not damaging because what they will say. Sometimes they will be damaging just because of the way they will approach the process. Yeah. You don't want you want someone on. You want someone who's going to be able to explain the nature of the limitations, restrictions, injuries affecting the applicants, and that's what you want to see.
Mathieu, it's been awesome having you here. I'm so glad. I've been chasing you, and I know you were very willing to do this, to come on and talk about this. Could you, just before we go, let people know where they can find you, maybe give your law firm name. People watch this podcast across the country, but if they were looking for a lawyer, and where would they find you, and who would be the potential clients that you could help?
So I'm Mathieu Picard. I'm a partner at Fidelis Law. We are a boutique litigation firm in Moncton, New Brunswick, and we serve New Brunswick and also the PEI. Mm-hmm. And we've been at it for many years now. And I had the chance of working with Dave Brennan, who's also a very fantastic lawyer in the field of LTD, CPP appeal, and all these things. And it's always a pleasure, Dave, to have a chat on these things. We should reconnect soon.
Yeah. No, Mathieu. Again, I thank you for this. And I guess that's it for now. We'll see the rest of you guys next time. And Mathieu, thanks again.
Thank you. Thanks.